Good morning, everybody. Good morning, Rod Hoare, the Rod Father. We're honoured for you to join us. Nice to see some friendly faces entering the webinar. We'll just give a few minutes for everybody to join this morning. Hope you're all well. Good morning, Debbie. Good morning, Debbie Davis. Sirius, nice to see you. Hope everybody's doing well this morning. We've got a really interesting session lined up. We'll just give a minute or two for everybody to join. How are you all feeling today? I'll tell you what, let's play a quick game while we wait for everyone to come in. Tell me 1 to 10 how you're feeling, what your vibe is. 1 being absolutely shocking, 10 being wonderful. I think I'm a solid 8. How are you feeling, Martin?
I'm a 10.
Oh, you're a 10.
I'm a
Love
10.
it.
Yeah.
Love the bullishness. Great. 8.5s. Ooh, we've got a Genki happy bunch in here. How are you feeling, Rod?
9.5.
9.5. Oof. Love it. Okay, well, if anyone's a sub 5, we're hopefully going to bump you up to an 8+. That's the aim of the game. So just by way of introduction, whilst we wait for the last few people to come in, my name's Eloise. I'm a co-founder and director of growth here at Vincere. So we're a recruitment operating system for labour hire, perm, contract, temp businesses. I'm joined today by Martin Richardson, who's someone that I've personally followed on social for quite a while. We became acquainted about, I want to say 6 months ago. Martin's a very interesting chap. He's the founder and owner at Ready Set Recruit Legal, which is the leading legal go-to for Australian recruitment agencies that want to avoid building their agency on quicksand. He's got an interesting background. So he's a lawyer based in Melbourne. He used to be general counsel at Adecco ANZ, where he oversaw all their legal services and was part of the senior leadership team. And in 2019, I think it was, he decided to go it alone, take all of that knowledge of recruitment and legal and start his own agency to help recruitment agencies of all sizes get their legals in order. Martin, you must have left a really cushy role there. Why on earth did you leave? You must have been paid a bomb. It must have been very stress-free. Why did you do it?
I wasn't in a sales role, Eloise. So it was 2017, actually. It was 10th February. So I left Adecco and I went to Sodexo. So I went to another corporate role. And that was, so I spent nearly 4 years at Adecco, but I went to another general counsel role with Sodexo. And I left there on the 10th of February, 2017. And my son, I'm an older dad, was born on the 11th of February. So that's why I did it. So I basically had 2 babies at the same time, my new business and Jasper as well. So that was a decision I made then. And then recruitment became a thing for me organically, really. It wasn't a conscious decision, but I because of my Adecco background and network, I was getting calls and I was focused in other areas. And then about 2 years ago is probably when I thought, you know what, there's a real opportunity here. And I really enjoy working with recruiters. There's so much energy and passion and the ability to, that recruiters impact lives. And I really like that because I'm on a mission. It's kind of my mission to change the perspective of lawyers. So then I can have more impact on recruiters and they can have more impact on the working lives of others. So it fits in really nicely with me. So that's why I do what I do.
And this is kind of one of the reasons why I reached out to you to see if you'd run a session for our customers and anybody really who's interested in covering themselves legally, but also maybe reframing how they use legals within their own agency to not just de-risk, but also to kind of use it as a competitive advantage. Because I'm seeing a lot of my customers, not a lot, certain savvy customers, I would say, mainly based in the UK actually, who are using things like terms of business, things that I think in recruitment we always see as being a bit scary or boring, and they're using it as a way to be different and win more business. So I think we're going to touch on that perhaps today. But let's get started. I think we've got most people on now. So agenda for today, we're going to be talking about legal blind spots. We're going to be talking about best practices. We're going to do a Q&A, and then we're going to follow up by giving everybody who's registered a free legal checklist, which is such a good resource. And thanks for providing it, Martin. It's awesome.
My pleasure. My pleasure.
Let's crack on then, Martin. The floor is yours.
Okay.
Let's
All right, thank you. Well, I tend to talk fast at the best of times, and we've got a short session today. So apologies if I do go through this reasonably quickly, but I've got some stuff to go through that I feel is really important. The first thing is this is not a legal 101. This is not the 3 things to put in your terms of business. that are going to save your agency. I've been a lawyer for 21 years, and at university onto that, I've been taught, directed, shown how to be a lawyer for a lot of that. And I made a realization working in-house that lawyers are trained to get someone from A to B. And the lawyer's job is the A, is to get you the legal document, and then you're on your own to get to B. And what I've realized is the more businesses that I've worked with and the more I've been involved, so in business as an in-house lawyer and then running my own law firm here, what I've noticed is the bit between A and B is often the quicksand. And that's where a lot of businesses and recruitment agencies fall down. Because, and you've touched on it, Eloise, there's an experience or a journey in that A to B for the customer or for the end user. So your clients or customers, your staff as well, your consultants, they are all legal users in the context of your agency. And so what I want to talk about today is really not 101 tactics, but mindset, because to me, where I see a mindset shift is where I see change. And, to quote Steve Jobs, are you living with the results of someone else's thinking? And I think that's a really powerful thing because, and we will touch on that a bit more, but are you living with the results of someone else's thinking? Is someone getting you to A and then you're having to live with that and then work it out from there? And so today it's really the three things to get you legally protected from a mindset point of view is you need to know where you're at. You need to know if you're making some common mistakes, and you need to know what you should be doing within your agency to impact that experience, that end user experience. And if you think about it and Eloise, we talked about this, if you think about your marketing copy, your website, your ads, the amount of money that businesses and agencies will spend on their marketing and their copy, but then the legals just get left out there. So,
and it's almost like totally separate, jarring tone to the rest of the conversations that you're having with the people you work with, right?
That's right. And so, if I can just touch on something for a minute, what I notice with agencies that come to me or have legal problems that arise or that are brewing, there are agencies that really struggle to sort it out. There are agencies that they get those issues or they have those issues and they struggle to work it out. And often it's these things that I see or hear coming through. Agencies feel overwhelmed. All the things, there's a lot of information coming in. There's a lot of legal stuff coming in. There's a lot of lawyers and compliance people talking about it. So it can get really overwhelming. And that's where the struggle can be. And maybe agencies don't understand where to start. You're overwhelmed but where do I start? What do I do? And number three is it's something I see, particularly in the PSA tender space, but this notion to a degree, recruiters, you're really focused on service, and this kind of notion that comes through, it's not spoken of, but I see it, which is I have to accept lots of risk to win business. I'll put that in a common thing you hear in a procurement context. Everyone else has signed it. You have to accept the contract to progress in the tender. That's what that is. That's the message that you are taking on board there. I have to accept the contract. I have to accept risk to be successful. So this is something, that I see the agencies that kind of struggle around this. They do have that bit of mindset, and there's nothing wrong with that mindset, but it is a mindset that can work against you from a legal protection point of view. Hopefully that's pretty obvious from what I'm saying there. Now, this is the one. Lawyers are a handbrake to happiness. So that is, I don't want to work with a lawyer. The perception of lawyers and the law as being a brake. I'd rather avoid it. I'd rather adopt a strategy of avoidance than have to deal with lawyers. And we were just talking about before lawyer jokes and a post I put on LinkedIn about lawyer jokes. Lawyer jokes I hear all the time. But when I dive into it, I think, what are lawyer jokes actually saying? Making jokes about lawyers charging by the minute and charging in the shower and all these other jokes. And, they're funny, but is there actually a belief there that lawyers aren't going to help me? The lawyers are there to work against me. And then the law and lawyers are a handbrake to how I do business. And that can actually impede progress and can impede protection.
It's just like, it's a bit rich, isn't it? We make these lawyer jokes. How many of us as recruiters have had recruiter jokes chucked at us? And it's like, it's a buying signal. You probably need help with your hiring.
Yeah. And I get it, right? Yeah, I'm sure recruiters hear recruiter jokes, real estate agents hear real estate jokes, right? Everyone in services has jokes about them, but when it comes to lawyer jokes, what are you actually doing yourself a disservice there in thinking lawyers are out to get you? And I hope we're not all out to get you, and I know lots of good ones, and I'm certainly not. But then there's the agencies that do it really well. And why do they do it well? Why do they get great contract or legal outcomes? It's because they're on brand. They're legal, and you touch on this. Their legal terms are part of their customer journey. They're part of the experience for their clients. They bring their clients on the journey with them. They don't just drop terms which don't represent their brand from a copy point of view or a messaging point of view, a tone point of view. Their consultants understand them. So they're part of their process, and they're investing in continuous improvement and the tech side of it as well. So the agencies that do this really well are those that aren't afraid of the legals, but they're not trying to be lawyers, right? I don't want you to be lawyers. You don't need to be a lawyer, but it's recognizing that between A and B, it's a journey, and your legals need to be part of that journey, not out in the ether.
On that note, Martin, just to interject, we've actually got a poll set up, and we wanted to ask everybody on the webinar right now, how many of you are offering dedicated training to your consultants, your team, around your terms of business, what they mean, how to present or sell them? We'll leave that running in the background, but do let us know. We'll come back to that. Martin.
Yeah, it's a great poll, and I would say right now, as in your own mind, on a scale of 1 to 10, how confident are you that your legal documents reflect your brand? Because I see a lot of terms of business. A lot of them, I need a map just to work out where they're going, and I'm the lawyer, right? So, they're not. There's often a fairly big gap, and that's I'm not having a go at recruitment agencies. That's the lawyers, and that's the reliance on people, and we'll get to that. But I have to have terms of business. They have to be legal, and I'll park them till I have to deliver them to the client. So, yeah, in many ways, these beliefs or these assumptions also talk to maybe the beliefs around where the law is in the agency, and maybe it's uncontrollable. You just have to put up with it, or maybe it's it exists out there in the ether, as I say. So I like to break it down to what the law actually is in my worldview, and that's a set of rules that govern relationships. So traffic lights, green light, you go; red light, they stop. That's a contract. That's a set of rules between two drivers. That's governing the relationship, because if those rules weren't there, you'd run into each other. So it doesn't exist out there. That's happening right there in front of you. You buy a coffee. I'll give you $5 or whatever I pay for a coffee, and you'll give me a coffee that I asked for in return. It's a relationship with a set of rules. So when I think about recruitment, these are the 5 categories that I come up with when the key relationships for an agency. So we pull the law in, the legals in from the ether, and we recognize day to day where they sit in our business. They sit in our client relationships, obviously, terms of business, PSAs. They sit with our contractors in our engagement model. It's employment. Is it employment law? Is it contract law? The independent contractors. What is it? With our candidates, privacy is a good example. We're accepting data and we're handling their data. So there's a relationship there with candidates. Consultants, I call these out as a specific category, one of the 5, because the desk is crucial to your success. So if you're running desks and consultants, they're a key relationship. The employment relationship, the performance relationship, the post-employment relationship, which I know is a subject dear to agency owners' hearts, unfortunately, with IP and restraints and the like. But that's another key relationship. And then you have contributors. So if you have co-owners, your shareholders agreements. You have an accountant or a lawyer. That's someone who's contributing to your business. That's a key relationship that is governed by a set of rules, your IT provider. So they're my 5 C's.
Well, what I'm going to say. You know what I'm going to say, Martin. You're missing a very important C, the 6th C, which is your CRM. If we've got any Vinny customers on the line, all of this legal stuff is useless, and you've got to centralize it in a system of record. Point of truth, which should be your CRM. Right. And there's lots of clever integrations around digital signatories and stuff, which make sure there's no excuse for any of it to live outside the CRM. You're passionate about the legal. I'm passionate about that bit. I can't let that slide, Martin. You know that.
Well, it's the vehicle in a way to the customer experience, isn't it? In many ways, removing that friction and that tension. So I hear you.
Well, you need to make it easy for when does the consultant have that conversation about terms of business? If we're
Yeah,
saying it should be baked into that customer experience, whether a customer's a contact or a candidate, we need to make it as easy as possible for them to get signed, right? So that's
that's right.
coming from the
That's right.
CRM out automatically, injected straight back in. None of
That's
this
right.
fussing around, paper signatories, any of that
Oh, we all know
nonsense.
how annoying, or attaching terms to email.
It's just annoying, right?
So I touched on the 3 steps. This is the first step about getting legally protected. Taking stock of where you're at. And there's some people who've probably seen this slide if they were there at the APSCO conference. But you've got your 4 indicators: high growth, low protection, high protection. And then what are the 4 quadrants? So if we start at the bottom there, hopeful. So hopeful is perhaps a startup, or it's an underperforming agency in comparison to the market and competitors. So underperforming in that context. So your sales are low, but your protection is also low. But I don't deal a lot in this because there may be not a lot of risk because you aren't being exposed to a lot of risk. But there is that quadrant there where some agencies will sit. Next to that is scarred. So scarred is maybe inflicts larger agencies, and I've certainly seen this. This is where every problem that's ever happened then has a lever pulled so it never happens again. And you end up in a situation where perhaps you are constraining growth because you are being too compliant or too protective around the legals. Perhaps you're not letting consultants or managers negotiate anything on terms of business. Maybe you're not showing how you break down your rates. Which is fine. That's a business decision, but that's maybe an example of how you are constraining growth because you're being overprotective, and that can also be, have consequences. But at the top, we now move into high growth, and we know that the market at the moment is booming for many, and agencies that are going through exponential growth and haven't caught up from a protection point of view, haven't got the foundations right, perhaps they're in the exposed because if growth is inevitable and success is inevitable, well, problems are inevitable as well. You grow, that's problems. And we'll get to a bit more context around that. So maybe you're sitting there, but where I'd love to see you think about getting to is the in control. So yes, we want high growth, sustainable high growth, and high protection. You want to be protecting what you're growing. So for me, plotting where you are today is the first thing. And if you're in that in control, that's great. If you're at the bottom of that, you want to get to the high. If you're elsewhere, well, that's good to know because you've got to start now and think, okay, well, maybe I can be doing some things a bit better.
Even if you're in control, I guess it's a constant thing, right? You still need to be doing sort of regular reviews, cyclical check-ins, that kind of thing.
Yeah, well, that's the continuous improvement development. It's not using, I'm going to probably mention cut and paste TABs a dozen times, and those that know me will probably be chuckling because I tend to bang on about it a lot. But it's a great example, right, of set and forget. Or maybe it's an employment contract from 2008 that you borrowed from an industry association you're still using. So, that you're not in control.
That must happen so
much. You may think you're
much.
protected, but you're not in control because your documents aren't fit for purpose potentially. And if anyone saw, the Rosado High Court just handed down the Rosado decision, which has put the contracting industry through the ringer. The High Court has just found in favour of WorkPack. So that's a great example where everyone's gone through this washing machine of stress and overwhelm around this contracting model. And then the High Court has just overturned the decision in favour of WorkPack. Now we have new definitions of casual employees, fair work, but we've gone through this angst, and it's a great example, right? Things just get turned around. So what does this now mean? Sorry for historical issues, but
I have no idea. That is one question for you, Martin.
Right? It's an example of you can't set and forget in any business. I don't even know what's going on. I have to read
it. Maybe a follow-up session in that.
Yeah. So we are where we are today, but where do you want to go? What is your brand about? What do you stand for? And who do you want to become? And this alignment piece and mindset piece from a protection point of view is vital, because how do you know, if you don't know where you're at and where you want to go, then how do you know what to protect and what's actually important to you? So for me, the best contract in the world will never save you if you haven't put the work in to what it is that you're trying to achieve from a business point of view. So because law is a subset of business, not the other way around, as I like to say, right? Law and contract shouldn't be driving those customer interactions. So then we move on to, well, are you making these mistakes? And these are, again, some mistakes or blind spots, as I call them. Now, this one resonates a lot. I had, again, after the APSCO conference, this has come back to me a lot, just this little phrase. So it's obviously works. If you're in business, you're in the legal game, whether you like it or not. Remember, rules and relationships, problems are inevitable. The law is in your business. So you can adopt an avoid strategy, but ultimately someone else is going to win that game. And I don't mean adversarially, I don't mean fighting, and that's not what I'm talking about. But ultimately there are rules that are impacting your agency. So you just need to accept it, that you're in the game. How well are you playing the game? Is someone else playing it better? Are you on the bench? Do you even know the rules? If you treat the legals as the afterthought, you're actually not protected, even though you think you might be protected. These have to be central to your brand and your experience for consultants and clients. And again, the avoid strategy, it's a strategy, but it's not going to get you very far, because problems are inevitable if your growth is inevitable. So cut and paste terms of business, relying on others to provide solutions without knowing the problem. What do I mean here? I mean, getting a lawyer to write a set of terms and conditions getting you to A, and you don't know what's in them, you have no input into them. So you are now working to someone else's thinking. You are getting your results are tied to someone else's thinking, because you haven't had input into those terms and what it means for your business, and whether that 3 pages of things to do with Personal Property Securities Act, which I see as a legal technical example, is that really relevant to your business? Or did a lawyer just put that in because that's what they did and you didn't have a conversation about that? Or did your mate down the road who's running a recruitment agency give the terms of business that he's borrowed from Hayes when he used to work there? And now all of a sudden you've got how many lots of thinking rolled into a legal document, and your results that you're achieving could very well be tied to that thinking. Those terms might not even be binding. So you don't need to be a lawyer. You don't need to be a lawyer. I don't need to be a mechanic when I take my car to the mechanic, but I like to know what it is. I like to have some understanding, some knowledge about what the bill covers and why the work was done. So lawyers shouldn't be out there doing things for you. You should be directing lawyers about what you want. They should be asking you questions about what you want. And if they're not, you should be asking them what it is they're going to deliver. You don't be the lawyer, but don't just go set and forget on these things, because you end up in this unsustainable, I'm relying on legal documents that are old, that aren't fit for purpose, that aren't on brand.
I mean, I have customers, we've got customers all over the world. A customer of ours in the UK who is entering a new market, Japan, so quite a legislative, unique market. And he, the MD actually said to me, "Okay, we're going to Japan. Yeah, I've got the perm contracts done, but I could do with an employment contract. Don't suppose you've got one knocking around, have you?" I was like, "Well, I didn't work it's been 10 years since I worked in Japan. You wouldn't want anything I've got." But that just highlighted to me, they've got like 150 consultants globally. It's not a small business. It just highlighted the attitude of just like looking for quick wins and like cut and paste terms, even at that level, which I thought was quite interesting.
Yeah,
quite scary,
and I
actually.
guess, and you're right, it's really interesting. Sorry to cut you off there, Alice. I would just ask the question of, why do you have terms? Like, why? I mean, if you're going, there must be a reason that you're using cut and paste terms of business, or industry association terms of business that you haven't done anything with. And I'm not harping on them, but that, it's another example, generic templates, or that are for services but not for recruitment, or your payroll company, if you're using a payroll management company, they've given you contracts and you're just using them. Again, nothing wrong with that, other than are you just outsourcing something because you don't want to think about it, and you don't want to bring that into your business. I'm just conscious of time here. Doing what you've always done. I've already touched on this. This is we've always done it this way. We've always engaged PAYG contractors. Okay. What's a PAYG contractor? I don't know what a PAYG contractor is. It's a phrase that gets used. It has no legal meaning to me, but people do it because that's what we've always done. We have PAYG contractors, or we always have independent contractors or sole traders, which are less and less. But good examples in a contracting sense of doing what you've always done. We've always offered replacement guarantees. We've always prorated our part-time fees. We always offer temp to perm discounts. We always only invoice on start date. not when we finish our service. That's just what we've always done. That's what everyone else does. So they're just examples. But when I think about the broader legal kind of world that we live in, it's just growing for recruitment. You know, we've got labour hire licensing, great example. We now have wage theft, which is a criminal offence in Victoria. If you want to look anywhere as a futurist for recruitment, look at the UK and New Zealand and look at the laws that are coming in. UK is just in Labor opposition, I think Labor, isn't it? Have just announced as a policy position 2 days ago, a new definition of worker, which is collapsing 3 definitions in the UK. So that's for gig economy. So they're looking to, you know, to fix issues as they perceive in the gig economy, modern slavery. We've got all these laws are impacting the sector. And if your business model is contracting, and apologies if I harp a bit more on contracting, but if this is your business model, then that's your business model. And you have to realize that you're not running widgets. You're not running a real estate rental book. You know, you're running people, and with people come a lot of laws, and they're just increasing. So it's not going out. And if this is a blind spot, then where are we at? Is this something we need to be planning for? We don't need to get overwhelmed. We just need to plan for it. If we've got a business now, are our foundations correct? Do we have a problem today, for want of a better term? We had it yesterday, we have it today, and we're going to have it tomorrow. Do we quarantine it? Let's not always do what we've always done. Let's quarantine it.
Sensitive word right now. Very much of the zeitgeist, that, Martin.
Which one?
Quarantining problems.
Oh, quarantine, yeah, sorry. Yeah,
I'm in lockdown, mate.
Yeah. Put it in a box, shall I say?
Yes,
or
that's it.
Might be in a box
that's
as well,
it.
I don't know. Aren't we all? So, you know, where are we at? What are we making some common mistakes? Do we have blind spots? And what are we doing? And I use the RAD method, ready, aim, do. I use this everywhere. So I'm using it when a prospective recruiter client rings me. I'll use it in my own mind to assess where they're at based on, you know, some of the things we'll touch on. I use it when I design documents and processes when I'm being engaged to do a broad piece of work. I've used it to develop consultant training, which I'm kicking off tomorrow. I'm running a beta program for a client tomorrow, which is for consultants at the desk to address some of these things. I'm using it today. This presentation is ready, aim, do. So I love this framework because do is just, we're just going to do things. We're just going to find a solution to a problem, but not understand what the problem is. But ready, aim, do is step back. Where are we? What do we need to do? And let's get on and do it. I used to say done, but I say do now because done actually sends the wrong message. You're never done. You do.
Constant with law, isn't it? It's shifting all the time.
Yeah. So, and I firmly believe if you do follow that process and invest a bit of time in it, then you can win the race for clients and talents, competitive world, and you can stay legally protected. And ultimately, you can do it without annoying clients, which I know is always a pushback from recruiters, and I get that. But you can do it without annoying clients. It's all about bringing the legals and your BAU, your sales process together. It's that gap between A and B of making your customers and your consultants and your talent at the center, because they are all legal users. They are all using legal documents, processes, impacted by relationships, connected by law, and they're all part of your sales process. So that you need to bring the legals and them along with part of the same process. I hope that's all making sense. It's not too esoteric, but bring it in. Don't hide it. If you're going to introduce terms to a client at the end of a sales process, they're going to be excited to work with you. And if your terms are 6 font, full of legal jargon, what does that do to your sales process? What does that do to your brand? Does it slow things down? It might not kill the sale, and I hope it doesn't because they've already made a decision, but what does it do? If you're having conversations about price and upfront, but you're not having conversations about other things like payment terms, and, you know, as Greg Savage will say, you know, getting some concessions in return for, in a negotiation context. But if you're putting things in terms and sending them after the fact, you haven't brought customers on a journey. And they're not lawyers either. And no one in that process is a lawyer, and no one wants to be, but are they thinking, what are you hiding? And consultants, if they can't explain them, well, I have to go off and find answers to these questions. So there is an opportunity to build these in early, introduce terms early. Real estate agents, by the way, are really good with this. We're in the process of dealing with real estate agents, and they're really good at setting context, being very clear on terms. Just an example, right? And it can work really well because it takes the friction out of things.
Yeah, I like that. Be on the front foot, and you've nothing to hide. They're your terms of business, right? It's your business, so you need to own it.
Your
So
brand.
just right now, exactly. So we did a poll about 20 minutes ago. We asked you, do you currently train your consultants in how to explain or sell your terms of business? Interestingly, very close result. So 53% said no, they're not doing any training, and 47% said yes, they are.
Fantastic.
So that's a very different result to what you got in your APSCO talk, wasn't it? Where you had 100 people in the room, and how many people stood up and said we're training?
Two, and one of those is on this call, I believe, and a favourite of mine. And yep, her hand was in the air. But yeah, it was how many people in this room onboard their new staff? All the hands went up pretty much. Keep your hand in the air if you onboard them in TOBs. Only 2 hands stayed up in that particular room. So, but that's great. I love that result. That's fantastic because that, that speaks to what I'm talking about. And then it's a case of how are you training them? What are you training them, of course, but that's fantastic. I'm really, really pleased to hear that. Mm-hmm. And not talking about indemnities and things, right? That's not training. That's boring. So foundations, to get ready, you need to understand your business model. Are you building it on quicksand? What is your engagement model? Are you using a payroll company? What's their engagement model? Because there's client, you, contractor management, payroll company, contractor. So, what perm services are we offering? Are we offering retained? Is that different from contingent? Yes. Is it different? Do you have an exclusive in the middle? What is our business model, and how do we price it? And how do we make money, and how do we want to make more money? So relationships, I've talked about those. What are the key relationships in your agency? There might not be all 5, but there's going to be some of them for sure if you're in business. So, and how do they connect to that business model? Strengths, whether you're a 1-person agency or a 101, not everyone has the same strengths. And understanding that can be really helpful, because when it comes to conversations, chasing invoices, difficult conversations with contractors or negotiations with clients, not everyone is good at that. And you as an owner, if you're an owner or a senior manager, shouldn't be trying to do everything either. So getting ready is having the ability to recognize where the skills are in any business as well, in my view. So, of course, we need to sort our legal documents. We need to stop using cut and paste legal terms. We need to invest in the messages, and we need to make it on brand. We're proud of our brands. You invest a lot of money in them. You want to distinguish yourself in a very competitive market. You talk about it. You have great Instagram posts which show that you're young, dynamic, whatever it is. And then you have legal documents which don't do anything for you in that context. You don't have to be a lawyer. You don't have to have legalese. There are great ways of writing things. And you need to be asking those questions. You need to be getting those documents right, because they represent you and they represent great outcomes.
Seen some great examples of this, Martin, in the UK, whereby there's actual legal copywriting firms who can help with this. I've seen some really, and also some, I think you mentioned, is it LinkedIn or Google, who represent their terms of business for one of their products in a kind of animated map. So there's some innovative stuff. I think we'll see a lot more of that. Yeah, I agree. It still needs to be binding and compliant. You don't want to be getting too overly creative, obviously. But yeah, you can think outside the box. But the thing is too, you can still be assertive. I've said this, you can still get protected, and you can be more protected if your terms are easier to digest and if you can explain them, because you're being transparent. So if your terms are logical and set out, you can actually get better results. You can be more protected because you're not annoying clients, because you're not hiding anything, and your documents reflect you, and they're consistent with what you're trying to achieve. Yeah. But then there's processes that sit behind that. And I've touched on that, introducing stuff to clients, during the process and smoothing out that friction during the process. And if we think about tenders, tenders are a great example. This is where I learned this, because in a tender context at a deco, for instance,
I had to go from a lawyer to a commercial manager who had to win legal points using commercial arguments. So it was all about introducing concepts early and not hiding things, because the contract would have just bombs in it that would detonate at any time. And procurement team just said, well, that's our contract, because they were dealing with their own lawyers and they didn't want to deal with their own lawyers. So you had to navigate your way through this really early as part of your sales process. Otherwise, you're running two different negotiations, one on price, and you've already agreed to all the contracts. And so it's a good example of getting stuff introduced through your sales material, through your marketing material, through your proposals.
Mm.
You know, we'll do this, but if we do this, then we need this back in return. Checklist, FAQs, negotiation guides. So our 50-50 poll, great. I hope these things are happening as well. If they're not, there's something to think about. If you came to me for terms of business, I won't give you just terms of business, or rarely. You will get an FAQ guide, because I learned that if I give you terms of business, I get you to A, and it doesn't help you or your consultants. Being able to explain them, have answers for questions at that point in time, empowers consultants, empowers you to be putting your best foot forward, and offers transparency. And the feedback I get from clients around that, just their body language, right? It just changes things, just simple.
People get scared around complex legal documents, right?
Yep,
They're recruiters, we're salespeople, right? And it's all a bit scary if it's legalese. So I think you're right. If you get on the front foot, and as a client, as a buyer, I just want to understand what I'm buying. I don't want any complexity if there doesn't need to be.
Yeah. And it doesn't have to be complex. No, I agree. But logical, set out, transparent. And staff wellbeing, I wonder, what level of frustration might there be because people don't understand and they're having to, they're your front line of dealing with terms of business. And are they frustrated by it? Are they feel empowered by it? Are they part of the process? Because they're the ones trying to make the sales, of course, and it's part of their journey. But does it exist out there, or are they able to bring it in? They are a user as well. And that's that investment piece. Again, we've touched on that with our poll. But so it is that negotiation training piece. This is what our terms say. Why do they say it? Not just what, why? And what are we going to do if we've got a great opportunity and we're going to be in a situation where, yep, we really want this opportunity. We're going to drop our price maybe, but what are we going to get in return? It's not just about what's in them and why, because a conversation can still stop right there, of course. It's potentially in that scarred quadrant, how we're getting up to in control. Everyone's on the same page. We're on brand. And again, in-house, I had to do this a lot, right? Because I was sitting in a business in an open plan where I wasn't charging by the minute. I was an open, available resource for free for everyone. So what do you think happens in that environment when you've got a lawyer there, right? Can you write this letter for me? Can you do anything for me? So I had to learn that this was the way for people to be empowered to do these things for themselves. It wasn't about me saying, I don't want to do it. It was about, well, we can do this better. So investing in staff, accountability. If you don't set up them from a training point of view, how do you hold them accountable for decisions? And I know this can get frustrating for business owners, when people make decisions or do things but if they don't know, how can they be accountable for them? And then there's a financial and business acumen, which is a big part of this. Because if we're dropping our price here, our payment terms, what impact is that having on a margin in the short term, medium term, long term? What is that doing to the business at a holistic or a larger level, at a bottom line level? I feel that's all really important, because the legal doesn't exist in the ether. Legal is part of your business. It's there to protect you, but it's there to be used as leverage to get great outcomes, so everyone wins. But it's like a waiter in a restaurant. The chef can produce the best food in the world, but if the waiter lets you down, if you know what I mean, if the waiter isn't delivering what the chef thinks they're delivering, and that message hasn't got through, that can be an impact on that restaurant, and we know that.
Yeah.
So lastly, to me, if you think about process and this being part of your business, you live with it, you're part of it, it's in there, you will simplify it. You don't need to be a lawyer. You'll be playing to your rules. You can get there by making it on brand. And again, as Eloise said, there's lots of great examples out there. You will positively impact relationships. Being assertive is not being difficult to do business with. If you need to assert your position because you're confident in it and it's the best thing for your business, that can actually have a positive impact. It can be a competitive advantage. In a tender scenario, again, everyone's signed this contract. well, we understand the contract and we understand those insurance provisions don't allow us to get that insurance in the market. That look on someone's face when you send a message that we actually understand that what you're asking us to do, no one can do. So they might have all signed it, but what have they signed? They've just signed a piece of paper. Just an example of you can actually lead clients in the world of work. Again, all these new laws, you can be a leader in this area. We can't agree to that because of the casual impact or the casual conversion impact. We need to work together on these things. So it can be impressive. And I have clients, I know they say this, it just makes life easier because clients don't see that we're hiding things, and you will be protected. You can get greater protection by being more open. Just going to let that one sit. You can get greater protection by being more open, not by hiding.
What's the average size business you work with, Martin?
Probably up to 50 employees. So, that band. I don't work for the big guys. The big guys have got their own lawyers and they don't need me. But, a lot of recruiters are in that micro stage.
And are they generally sort of established businesses or startups?
Yeah, they're growth. They're in the growth phase. Yeah. I mean, startups, I've got my own, solutions now for the startups. I don't think startups I don't want them using cut and paste, but I don't think they need to be spending one-on-one time with me to get them going. They just need to be getting great legal documents. So I kind of try and fix that problem, but it's growth. It's that three-year plus. I've got clients out there that have grown exponentially in 12 months. The Afterpay model. Maybe not that big, but there's clients out there that have just grown exponentially in the contractor space, but they're generally in that, and they, things have gone wrong, or they're ahead. They want to get ahead of the game, but they're growing.
Yeah.
And white collar, by the way, I don't do blue collar. It is white collar professional for me as well.
Understood. I mean, I've got a couple of questions where we've run over. We kind of thought we might do.
Yeah. Well, sorry.
I've got questions. You give us your big takeaways, and if we've got time, I'm going to pepper you with a few questions.
Well, I think hopefully the message has got through. Getting your legals aligned. I don't want you to be a lawyer. I've said that about 6 times. Don't think you're a lawyer. Don't think you have to write like a lawyer. This is about your brand. This is about making legals as part of your brand and being open and getting protected. And who do you want to be and where do you want to go? Are you working with the clients that you ended up with or with the clients that you want?
I like that one.
And you can, to me, you can win the race. So you don't have to accept risk to be successful. But it's important to take a step back. And are you building your agency on quicksand? And that's probably the biggest takeaway. What are the foundations of my business today?
I think you've given us so much to think about there, and we've had a stream of questions coming through actually to me. So we'll just do a couple if you're cool with that, Martin.
Of course.
But one that's come up twice is around commissions. So when you're employing consultants, should you include the commission scheme in the contract when you hire them? And if you do, should you put some variances in there?
I'd say no. Because the legal answer would be you don't want commission to be seen as part of the base salary. So if you have a scenario where redundancy in a role, whatever it is, you don't want there to be a confusion about commission, discretionary in a way versus base. So you want to take it out. And I think the other thing is too, a commission plan will allow you to have a period of time the commission plan applies to, 12-month period. You can then adjust the plan on a yearly basis. Different consultants can be on different plans. You control it. It's like any incentive. It's a short-term incentive, to use a corporate speak. It's a discretionary policy. Now, I know that it's expected in recruitment. That's how they make their money, but it doesn't mean that you don't want the flexibility to be adjusting the commission plan outside of the employment contract. A contract has to be, every time you want to change it, it has to be agreed as a contract, whereas a commission plan sits outside the contract as effectively a process or a policy. So you want to keep them separate.
Okay, good. Because that's what we do. Jessica Fassett has a question. She says, do we require clients to sign terms? So implicit in that, I guess, is can you just send candidates across with terms attached? The clients actually have to sign them or not? I think that's what you're saying, Jessica, although correct me if I'm wrong.
I suspect that's, and great question. The question I get probably the most A client hasn't
Really?
signed my terms of business. What do I do? Yeah, because it happens in recruitment. You're working really fast. So great question, Jessica. Quill and ink and delivering via pigeon to I never sent terms of business. And in between is recruitment often. So boring contract 101, you can't introduce contract terms after the fact. What that means is if you once you've entered into a contract, you can't then enter into other terms. I always use the example of the car park. When you go to the car park, there's a gate, you put your credit card in, but right there on the other side of the gate is the terms and conditions. The idea being that before you are granted entry, you've read the terms and conditions, you've accepted them, you put your credit card in. If you open the gate and went up to the 3rd floor and the terms and conditions were there and you ran into a wall on the way up, those contract terms that absolve all liability of the car park owner are not part of the contract because you didn't have a chance to see them before you entered into the car park. So if you're sending terms of business on an email, if you're not after and at the same time that you're introducing candidates and they don't open the email or they don't open the terms of business, there's an argument and a successful argument in a case a couple of years ago in WA around this for a legal recruiter who floated a candidate. There was a few other facts in this, but ultimately the court said, no, your terms of business were just attached to the email with the candidate details. You released the candidate details. You didn't really call out the terms. You didn't call out any of the key terms in your cover email. So how were they to know? I mean, the court actually said, and you're going to laugh at this, the court said it wasn't even clear whether the candidate or the client was to pay the recruiter the fee for the successful engagement. Now, we all know we don't charge candidates fees and it's probably illegal in some places, but that was the thinking at a pure legal point of view. Well, no, we didn't even know there was a fee, let alone who was paying it. So you need to make sure there's a reasonable opportunity. Paperwork, process, CRM, grabbing, every time you sign terms of business or you have terms of business, putting your key terms in a cover email. We will charge you a fee of X if you successfully engage this candidate. Here's our terms of business. You can see the definition of blah, blah, blah. Our payment terms are this, the salary band, whatever it is. If you put them in an email, you've got something to point to say, we made the client aware before they opened and went further.
That whole question there was the reason that we created our live list feature. So we're doing a lot of work with a company in Germany, and things such as an audit trail of when a candidate was sent across, if the email was opened, terms signed, etc. It's just all centralized in a dashboard as a CYA. Cover your on all of this stuff. Listen, we're going to run out of time here. I've had two other really good questions, but maybe if we do another session, or people can just contact you and reach out to you on LinkedIn, they can kind of carry the conversation on stuff around termination clauses, how to give us 2 or 3 things to prevent customers not paying you, all quite juicy stuff. So what I'd suggest is that after this session, what we're going to do, we're going to send you an email which contains the recording of the webinar, the slide deck, a really useful legal checklist from Ready, Set, Recruit Legal. And if anyone's interested, they can just reach out to you, I guess, Martin.
Absolutely, happy to have a chat.
Interesting solutions and products.
Happy to have a chat about any of this contact or about any things that I do. My website's got some stuff on there as well. You can check out some videos, etc. So.
Listen, everybody, thank you so much. And thank you so much, Martin. I love talking about all this stuff. It's such a nice break from talking about technology. I find it fascinating. And hopefully we've given you all food for thought. Thanks, everybody. Have a wonderful day ahead. Take care.
Okay. Bye-bye.
Bye-bye.